I couldn't find it in.
Okay. Are you on? Okay.
You couldn't find it, Jeff.
This is a meeting of the Raleigh Zoning Board, November 20th, 2014. I'm going to open the hearing as clerk of the zoning board. I want to make a couple of brief, quick announcements. As a result of the absence of our chairman, Don Thurston, this evening, who's unable to be with us, the normal course of events in terms of succession for the chairmanship is typically that a vice chairman steps up. In the absence of vice chairman, a clerk will act as the chairman of the meeting for that evening. We have no vice chairman, as you know, so the process most properly carried out is for us to elect one of us to serve in that capacity. So before we go any further with the meeting, I'll entertain a motion from any member regarding.
I'll make a motion that we make Tom the acting chairman.
Is there a second?
Second.
Any conversation?
Nope.
All in favor?
Aye.
Any opposed? Okay, so moved. So going forward, I'll chair the meeting this evening. Keep in mind, this is only an election for this evening, and that assuming Don is going to be back with us next in December, at our December meeting, he will resume his duties. Otherwise, at that point in time, we will go through the same exercise again. First order of business tonight, approval of minutes. We've all received copies of the minutes that are also in front of us. They are lengthy. I am not going to read them. There were substantial minutes from the meeting. Has everyone had a chance to look at them?
Yes.
Read them?
I did.
Sufficiently well enough that you're comfortable, Peter?
Picked them off the computer.
Yes.
Make a motion.
Any questions about them? Any? No questions? No additions, changes? And
Make a
motion to
motion,
accept?
we accept.
Second?
Second.
Motion's been made and seconded. All in favor?
Aye.
Any opposed? Okay, minutes are approved. Excellent. Now, let me see, next order of business. Next order of business is to review the Deborah Smith case, 95 Weathersfield. Again, the decision needs to be simply signed. We discussed this at the last hearing and voted to draft an approval.
I've read it.
If everybody, has everyone read it?
I wasn't on the case.
Right.
I have read it.
Okay. We're missing Don and Bob for signature, so they'll have to sign during the week. Bob Poole.
Oh, he was on the case.
You'll remember, and you'll remember that the substantial component of this particular case involved simply a request by the applicant for us to authorize a lot that had been, whose actual dimensions had been subject to debate by the property owner and a butter actually since our last decision on the property, which was back in '04. They had apparently come to a conclusion and agreed to where the property line would actually be, and the information, the application to us was aimed at asking the board to confirm as an amendment to the prior decision that the new lot would actually be accepted because it's a downsized non-conforming lot. Procedurally, what needs to be done is, while we can do that, we can't do that until it's an accepted lot through the planning board, so the planning board has to actually approve the lot. So what the decision basically states is that, subject to the conditions originally found in the first case, and subject to the applicant going to the planning board currently and getting the lot certified as a legal lot today, that our decision would in fact allow the classification of that lot as an acceptable lot for a two-family structure, which is what occurred in the first decision. So that's essentially what is said here, as opposed to going through and reading it. So if you have any other questions, I'm happy to entertain those, or we can discuss it further, but I don't see any need to devote any more time on it, in which case we just have to sign the original here, which Nat and I will do. There were 4 of us on the case: Nat, Don, Bob, and myself, and then you can just get this recorded as soon as you get their signatures. Yeah. Okay. Next order of business, continued public hearings. First hearing, 1503 Artistic Landscapes on Newbury Turnpike. I'm going to read some information to the public. Oh, here's Bob, excellent.
Very cool.
I'm going to give him a opportunity to join us.
Good, he gets the opportunity to sign it.
That's right.
Hey, my apologies.
Okay, all right.
You get that, you can sign.
You can, yeah, you can.
Now what?
Yeah, let's take a minute now. Why don't we just have him sign it?
Okay.
That's the decision that we reviewed.
Okay. I read it.
We've discussed it, and we just need to have your signature on it.
So you have plans for case separation? Yeah. Absolutely. Just ask and you'll receive. That's a good idea, very good idea.
Okay. This, in fact, is a new hearing based upon a desire by the board to properly classify the application as a request for a variance, as properly stated as a result of a advertising incorrection. And I want to read the following just in order to alert those who may be listening at home how we normally proceed, as well as those who are here. The board is familiar with this process. Basically, the public hearing will proceed in an orderly fashion, and we ask for cooperation in the following procedure. Everyone present will be given an opportunity to be heard after the application is presented and the board members have asked questions. The secretary will be recording what is said. Therefore, when you address the board, begin by stating your name and address. Speak slowly and clearly. Only one person will be allowed to speak at a time. At this point, do any of the members have any conflict of interest in this?
No.
The public notice for this application was posted at the town hall, sent to a certified list of parties in interest, and was published in the town common on November 5th, 2014, and November 12th, 2014, and reads as follows. Public hearing will be held at the Town Hall Annex, 39 Central Street, on Thursday, November 20th at 7:20 p.m. to act on an application received September 3rd, 2014 from Artistic Landscapes, care of Tony Hurley of 1 Sawmill Way, Georgetown, Mass. Applicant is requesting a variance from the Board of Appeals for installing a sign with the requirements of sections 8.5.4.1 of the Raleigh Protective Zoning Bylaws. Property is located at 111 Newburyport Turnpike, Raleigh, Mass. Property is in the Business Light Industry District and is shown on Assessor's Map 14, Lot 17. At the public hearing, members of the public may ask questions and present evidence that supports either the approval or denial of this application. The purpose of the hearing is for the board to hear and consider the pertinent facts relating to the application and to approve with conditions or deny. Before hearing from the public, the applicant will be allowed to present their case, and then board members will be allowed to ask questions or comments. At this time, the applicant has the floor. And Tony, before you speak, I do want to just make a couple other notes. We have received a letter from Mr. Hurley addressed to both Don and myself. I think you all have copies of it. That's substantial in length, and I think there are a lot of elements to it which I think are quite relevant. I'm not sure whether I need to read the entire document no, okay. Number one. Number two, as a result of the prior hearing on this case, one of the elements of the board's actions was to contact town council with regard to comments that town council made to the board requesting, after we requested information about the status of a variance and the status of sign dimensions. In that letter, town council stated in very general terms that there are some instances in case law where variances have been granted for sign dimensions. He wasn't specific. The board determined it made sense to contact him. We did reach out to him. There is a copy of that email in the documents we have here that I sent on behalf of the board to town council Steve Fletcher, asking for that information. He did respond, as you see, indicating he would get back to us by tonight. He did not. We can discuss perhaps the relevance of that or not, but we don't have that information at this point, so we can't factor it in. I think, given that information, we do not have anything further from any other element on this case. So, Tony, talk to us about your letter and talk to us a little bit about what we should think about.
Sure. I'm Tony Hurley with Artistic Landscapes, and in the interest of continuing from last month,
Yeah.
I was able to identify a few instances where zoning boards have approved sign variances. 3 of them were right here in Raleigh. So I highlighted those three first. And then I went to some other towns because one of the comments that we were discussing was what other boards have done. So in Reading, in Burlington, in Beverly, they've all issued variances. And some of them are, I think it was like 116 square foot sign instead of like a 30 square foot sign. So, and they've run the range where everyone is granting variances. So that, I don't know how many cases you'd like to see, so that's why I said let me grab 3 from Raleigh and 3 or 4 from other surrounding communities. That way we know we're not trying to set a new trend or anything like that. The topography on Route 1 where I'm located is the reason for this request. And it seems to be, now that I've done more research and found on the Dunkin' Donuts case, when it was approved to give them, I think it's 16 signs on their building, they said the topography with the hill that's just south of the Dunkin' Donuts lot, which is the hill right in front of me, was the basis for granting that variance. So those are some of that's the highlights of what I've done. And in the 3 pages, I've tried to put in context of what I just told you. And the other 20, 30 pages behind it is the actual minutes from the local boards. And I've included 2 pages of the signage from the sign company, where he came, took a picture of the building as it stands right now, and said, okay, if we went with the 10 square foot sign, this is the way your artistic landscape sign would look, versus the 41.25 square feet sign that I'm requesting. And that should be like pages 4 and 5.
So option A is your preferred one.
Correct.
Tony, are there any other elements regarding placement in this request?
If the board, this would be subject to a future filing, it'd be a new variance in that. When I've seen this on the building as it is right now on option A, I've shown a few people, and within the town and outside, everyone's like, well, why is it stuck between the first floor and the second floor? It looks misplaced. And then when I was reading the variances, they said that if it's appropriate and aesthetically pleasing, that was reasons for granting variances. In hindsight, I wish I had put a request in for the variance of putting the sign above the second floor. No, on the same location, just above the second floor windows, because I think that would be aesthetically more pleasing.
I don't think that would change the variance, the rear location.
I don't think.
Yeah, I think it would be just
I'd
fine.
just assume do it now.
I think it would look better up top.
Okay.
So,
Good, because this
yeah,
looks
if
foolish
you
now.
got that hill coming down,
Yes.
going up high, you know,
You can see it.
yeah, yeah. I mean, if they can do it for Dunkin' Donuts, I don't see
Right.
why.
Thank you.
And it fits into the building nice, it's neat, it's not, you know, an eyesore.
Tony, the only thing I don't think we ever saw that I was curious about, and we wouldn't have seen it because you wouldn't have shown it to us necessarily, is, and I was trying to gauge this looking at the site, is this the sign that's going to be on the property that's going to be visible north-south?
Right.
What is that signage actually going to be? Is it going to be just artistic landscapes up near the top? That's about, looks like it's about 15 feet up. Where is that going to be? What's that going to be like?
It's on, it'll say artistic landscapes and give the phone number, and below it will be the whiteboard that you can put some lettering in. But it's going to be like 7 feet above, because last winter, since I've owned the property, we were watching where the plows were sending the snow, and any sign lower was going to be taken out by the snowdrift. When they come down the hill and plowing, it was going to take it out, so we had to raise that.
You're not going to be up, you mean you raised the whole thing? It's going to be at the top, that it was originally lower, the whole thing was lower?
Well, you never saw that design of it lower,
Right.
because we were trying to figure out what is the right height for that location. And the way the plows were coming, we said, no, we need to bump it so it's, I think it might be 5 feet, the bottom of it might be 5, 6, 7 feet above grade.
Yeah.
I forget the exact dimensions.
Yeah, yeah. Well, I was familiar, as is pointed out in Tony's letter regarding the Dunkin' Donuts sign, we remember doing that sign. And part of the, it's an accurate case of a variance being granted, and the substance of that thought process, I don't find it as directly relevant to your case, because that is a case where the properties involved are nowhere near the sign. you know, the buildings where the businesses are, particularly where Ace Hardware had gone originally, are so far off the road, you don't even know there's anybody out there. And to go all the way up Forest Ridge, you think it's just conservation land up there. You have no idea. That not as directly applicable, but certainly, you know, a soil-related condition, as far as I'm concerned. You've got, you know, a property built nowhere near, a physical structure built nowhere near where the signage could be, so that's part of the reasoning we granted that. I wasn't involved with the Dunkin' Donuts, were you in the Dunkin' Donuts?
Yeah, I mean, yeah, that was a building inspector over Topsfield who built that whole place. Maybe ex-building inspector.
Phil, any thoughts on it?
Well, I would think, if at all, it would simply have to be the fact that, I mean, certainly the building, as you view it from Route 1, it is physically located way below, the foundation of the building is way below Route 1, which is a characteristic of the land. You know, I'm trying to be as generous as I can to the applicant in thinking of how to justify a variance. Certainly, you know, he is set back, which was, he's not set back as much as Market Basket was, but he is set back. And you like to be able to think that, you know, he has a right to have a sign that people can see. I mean, to have a sign that's there but is nearly invisible is almost useless.
Right.
So if the land is, if the building is situated where it's situated on the lot, that far back, I mean, it's not that he's, you know, a mile back, but on the other hand, he's not right on Route 1.
Right.
I would not have, it wouldn't bother my conscience to vote for the variance.
Gentlemen? Opinions?
I agree.
Matt?
I mean, it's gonna be on the building, it's gonna be, looks like it's gonna be a nice looking sign there. You know, and then you can't go back any further, there's wetland all around there.
He doesn't have enough lot to go back anymore.
Yeah, no.
He's like, he's got it on a lot. Well, I feel similarly. I don't see, I agree with you, Bob. I don't think it's really that much of a stretch because the property, the structure is clearly well below the street line
Yep.
because of the land. I mean, it's not even slightly close. I mean, there's a, you know, and you don't know you're there until you're coming on top of it, so arguably, there's justification for signage to be where it is. And I went and I sat and I parked across the street and I looked at the building, I watched cars drive by, I counted windows to see how cross it might be that I thought acceptable. And looking at your sign guy's depiction, you come across about 7 windows here. And I viewed actually going as far as 10 being acceptable visually, thinking that that would strike me as obtrusive, not only where it is, but also above the windows. And I think your point is right, Bob. I think at some point, if you can't read signage, what's the point of spending the money and having it there?
And what you're talking about is putting it up here.
Yeah, can we assume it would be
In the middle of that.
In the middle of the above area, it looks like it's in the middle of the two windows. Would it be between the middle and the upper roof line?
Correct.
That's where it would go, up here.
Yeah.
Middle meaning top to bottom, not right to left.
Right,
Is this,
on the left side of the building. So exactly where it is here, but up above,
correct.
yeah. So,
It's not a busy sign either, you know, you're gonna be driving by 40, 50 miles an hour to go, you know, take a quick pic, know what it is.
yeah, now, are you still seeking the back, the sign to be lighted?
Yes.
Because that's not something we can pass judgment on. We can pass judgment on size, but we can't pass judgment on any kind of lighting. That's the planning board's purview.
Yeah.
As I recall, you said there is no retail
Correct.
here.
The lot is not zoned for retail, so.
Okay, so the decision will reflect that.
Okay. Well, are you constrained by that already?
I'm a light business industrial zone.
Yeah.
I personally don't know what that meant, what Bob just said about.
Well, if there's no retail, right,
Right.
why do you think you need to?
Well, I don't have retail on the site, but I'm going to sell to you as a homeowner and to do our services to you at your house. So you just can't come in and say, I wanna buy a flower, I wanna buy a stone. But I would go to your house and build you a stone wall.
In other words, I'll meet you at the house.
Yeah.
Yeah, that's my understanding.
No, I was just curious, I mean, why, oh, that's not ours anyway, so that's no problem.
Now, the only other element I had, like I said, is Steve Fletcher, who was going to get to us, didn't get to us, but there is evidently some case law out there which suggests that, and I don't know whether it's these cases that you related here that for some reason, were disputed, and that's how that became case law, or whether he has just looking at this kind of situations. I think it was nice of you to bother to go get these.
Well, I mean, you think he should have got to us anyway, I mean, we can't make the guy wait another month.
No. I don't see the need, because the more I thought about it, the more I looked at it, the more it seemed to me anyhow that it wasn't an obtrusive kind of situation, and I didn't see why we couldn't act on it. I didn't think we were stretching too far on the variance and the hardship issue because of the way the structure is physically located on the property. So I'm comfortable with it. I think we can draft a decision on that basis.
Can I ask
We,
one more question?
Sure.
When you do your vote, will you specify if it's for 10 windows or, whatever the sign?
I think that's necessary.
No, I think we need to, what we have in front of us is what we're likely to approve, with the only suggestion, with the
It's
only
180
modification
feet.
being, placement on the building.
Correct.
Okay.
Well, do we have the, yeah, we have the dimensions.
It's 118 inches and 24.
Right, that's 6
So
windows.
The dimensions are there, so it's,
Yeah, as long as the dimensions are
yeah,
there.
Yeah.
and it looks, I assume he's gonna be at the end because it looks nice there.
Correct.
It would be kind of lost out the other way. I don't think you have to count windows.
Well, do we want to designate where it is? Do we want to say it's on the left facing
Say
wall
left front?
between
the top front?
second bank of windows and the roof line? On the left side of the building do we want to provide any leverage on where you put it? Do we want to give him any room, or do we want to say, it starts at the left side of the window and run that far?
Well, you can say, as depicted, except that it be on the above the second row of windows rather than above the first row of windows.
Okay, well, so that's sufficient.
Of the second row.
You know, since we have
We have, we,
the
right, we have,
depiction,
we have a
It's
depiction that's
actually-
very accurate.
It's actually the top row.
Yeah, that's fine.
It's not only the second row, it's the top
On the
row.
roof line.
Yeah, between the, well, but, yeah, between the second, but you're fine, as depicted above the second row of windows, facing the building on the left side. That way it doesn't end up over here, if for some reason there's something that would change.
Well, if somebody starts,
That's,
where is the first row built? Is the first row up above, or is the first row down below?
well, we can say the top row.
The top row, you've gotta put a designation of top row,
Okay.
and that wouldn't be any question.
Yeah,
that wall is the west wall, if that helps at all.
yeah,
It's
right,
I
the
mean,
west wall.
everyone here knows it's going to be on the side that's facing Route 1, but
yeah. Yeah, we're just gonna refer to this document, because it's nice and stated. Okay, any further discussion?
Yeah, he cites the sign law 8.4.5.1. It seems like he's okay there, also with 8.4.5.2, that the sign is going to be exactly 15 feet, so he meets that. But the question I had is, we're given the variance apparently to add to the sign's gonna be more than 20 feet above ground level.
Correct.
So it'll be 8.4.5.3 would be in violation of that. So the sign would not be above 20 feet from ground level. And we already understand that the building is well below Route 1. So it seems like we would need to make adjustment for that in variance.
Wait a minute.
Were you getting that height from?
You want that?
What was the?
That's on page 57,
Yeah, now read.
8453.
Yeah. Have you got, yeah, we don't have anything. That's 2 feet. Oh, I see, 33, so 2 feet. You have any, Tony, what's the height of the building?
29.5 feet.
29. That's the front elevation to the high
Correct.
point. Just under 30, which is what it is. 20 feet is 10. That's probably that whole proportion.
Yeah.
Yeah. Well, why can't we simply just grant the variance to include that setback clause? We'll give him, we'll simply give him a,
We've got to come up with.
we'll define.
Yeah, the 20 feet's on the window, so we had to go above it,
Right,
so.
so,
You know, we gotta come up with all the
Mickey
reasons.
Picky from the other
well, I think the reasons can still substantially be the same. I mean, there's, it's,
Right, same.
it's a dimensional issue relating to the placement of the structure on the property, which places it below the level of the street.
Yeah, actually, that one issue is probably easier to justify than
20 feet above
anything
the
else.
road or 20 feet above,
That's right, because
Gotta
if
be able
it
to
says
see it.
ground level
yeah,
from the building is already, what, 6 feet below?
below, you're in a hole more than 6 feet.
Right, so that's the easiest of all to
Yeah.
to justify, really.
Yeah. So that's good.
Okay. Well, said as such, if there's no further conversation, what are you digging for?
Am I looking for the zoning act,
Okay.
where that's specified in chapter 48?
I'd entertain a motion then.
I'm gonna make a motion as presented.
Well, he's gonna have to amend the application, I think.
Why? We're just moving it up.
Well,
We're not changing the size of the sign or anything.
it's just that the application didn't ask for a variance from that section. I mean, I think we wanna make sure that,
What do you mean that section?
well, the application was for a variance from a particular section, and that was not included in the application, right? So we gotta make sure that we're gonna grant a variance for all the relevant sections. A variance from,
Can't we, this is not unlike what I think we ran into last week to some degree, where I don't know if necessarily, certainly hasn't been the case in the past, where we can assume that an applicant, it's incumbent upon the applicant to know every, right?
no, I'm not,
But
that's right.
can't we simply say,
I just wanna deal with it.
upon review, we concluded that in addition to, as pointed out by Phil, in addition to the original request for the variance for sign dimensional approval, we also found that there's a height issue. And he's got to, and in order for the sign so granted for size to be placed where he desires to have it placed, that we'll have to give him, the variance will include section da-da-da-da-da.
Yeah,
And then
yeah,
we,
yeah,
and
yeah.
then we, as a condition, we'll state, do you want to state, do we need to, you want to state specifically between a certain amount of feet, so he can't go anywhere in that 10 feet? Do we want to say between 20 and 25 feet? The sign itself is,
I mean, it
is
can't go any
2
higher than the
feet.
building. I mean, it's kind of unusual where it is, it's set down. You know, I mean, the ground level is in the hole to start with. It's not like it's on the road, the normal, well, the structure that we have are at that kind of height. And I'm looking at the buildings in the industrial park, those signs are up more than 20 feet. It's with bay glass in there when you go inside.
Yeah, well, that would have been the plan, right?
Yeah, so, I mean,
Whether they included that. But I don't see why we couldn't do like you're saying.
no,
Well,
I
we can't
agree, I
just,
seem to agree.
yeah,
I mean, we can say,
As
to,
long
not
as the
to exceed.
decision references the appropriate
specific,
sections
yeah.
from which he's getting a variance.
Yeah, I think so, And then I think as a condition, we can say, unless you think it's not necessary, unless we just leave it, if we just say he has a variance to it, then he can put it anywhere he wants in there, as opposed to saying he can have his variance includes the height differential, but it's no more, he can't go any more than 27 feet high, or 25 feet high. Does it make a difference? I mean, you're right, can't go any higher than the building.
And it's not that much off, really. I mean, the windows are probably, what's the building, 25?
It's, the top of the window's like 21, I think.
Okay, so it'd be right in the window, you know what I mean? So,
I would, from my point of view, if you don't stipulate, that's better, because we have steel trusses or something holding up the wall.
Yeah.
So depending on where we have to
Actually attached.
go
to the
through to attach it,
right. no,
it's
secure.
going to change by 8-10 inches.
Yeah.
So
you know.
it could be a complication where if we make a decision tonight of X feet,
Yeah.
and that's where one of the supports are, now we have to go up or down,
Right.
and then we're out of compliance.
Yeah.
And that's important to get that secured correctly so it doesn't get blown off.
You know,
Yeah.
here's, for the variance, here's the 4 questions.
Questions that
we
have to be
to
addressed.
answer,
Okay,
you know, and that's chapter 48.
okay. Yeah. Okay, so did you complete a motion?
No,
we
still
didn't.
working on it.
I mean, make a motion that we, as presented, and by moving the sign to the top part, it's not gonna go above the roof for sure. And it goes on that left side of the building, the top part of it, above the windows, second floor windows. I don't know what else you want me to put in there. I mean, you got an unusual shaped lot, you got the highway there with the site. You know, the building is dropped down. I think we can do it there. I don't have a problem with it, I mean, that's my opinion.
I don't agree. You,
Like it?
good?
I'll second the motion.
You'll second the motion? Okay. Lisa, do you want to try to, do we understand what we're approving?
Yeah, I do.
Well, then, given the motion to grant a variance based upon the application as depicted, and a change from its originally allowed size to this size, I think what we do is we vote to draft a approval decision, and then the decision will be signed at the next meeting. So with that understanding, on this motion to draft an approval decision, all those in favor say aye.
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 Any opposed? Okay.
Good, thank you.
Tony, you understand what will happen?
Yes.
We'll draw the decision up. It'll be reviewed finally for verbiage, and then it'll be available December. Lisa will record it as close to then as she can, because we're banging in on the Christmas. What's the date?
18.
18th?
December
Oh,
18th.
so we got a week. Okay. All right, good. Okay?
Thank you very much.
Okay.
And have, Lisa, have you got a copy of this upstairs?
I do upstairs.
Yeah, very good.
Okay, because variances are, well, its variances are section 10
Uncover the basis.
here.
Please.
And this is the,
My zoning, my zoning paper doesn't look like that.
may not,
You probably got a new one.
You got a
They have
new one.
new one.
you got a new one, but that part portion doesn't change. Section 10 is variance. Huh? I haven't got a later one, see, this was back in, huh? Yeah. They didn't put a date on it. Back when Paul Salucci was governor.
Okay. Let's move on.
Another content.
We're actually pretty close. That's pretty good. Okay, again, for Sean, I don't think you were here at the beginning of the meeting. Our chairman, Don Thurston, is not able to be with us tonight.
Right.
So the board has authorized me to act as clerk, act as chairman for this meeting. We're going to continue the case with you. We're going to go forward with it now, discuss it further. And if depending upon whatever we do with the case, if Mr. Thurston
Yeah, I
is
know.
not here next hearing and the case is still on and still being heard, he'll resume his duties. If he's not here, then the board will again have to appoint, could be any one of us, to serve in that capacity again.
So did we have 4 last time? Is that what we did?
Yes.
And can I go forward with?
Well, we can't, candidly, we can't act, we don't have a quorum to vote,
Right.
okay?
Because I need
we-
4.
Yeah.
Right.
And there's only 3 of us
Because we
tonight.
didn't have 5 where I could play.
Right.
And I didn't bring my statute. Do you have the ability, under the Mullen Rule, if he's not here for one meeting, to review what took place?
Yes.
And then he can
still be
deliberate.
Right,
But if he misses the next one, then we can't.
then he's
So we
done,
got one shot.
right.
And we can talk about it tonight, but we're not gonna make a decision, because that can't happen until he comes back to sit.
Right.
Okay, all right, I understand that,
It's an unfortunate case. I mean, in my knowledge of being here for 9 years, this is the first time Don has not been in a hearing.
is he okay, or is he,
Well, he has some back-related issues
okay?
that are creating what could be some prolonged recovery at some point.
Oh,
He's
So,
got surgery.
yeah, it's not like a flu bug that'll be gone next Friday or something like that.
so if we're not gonna be able to act until the next meeting, should we wait until then, and then I have another meeting afterwards?
Well, we can certainly.
And I don't have an issue with a cease and desist. I mean, I think that the building inspector is satisfied now, and we're not, this isn't for evidentiary purposes. So this is just as a preliminary to figure out where we go.
Yeah, exactly.
Because if he's gonna be out for a prolonged time, I'd rather not do tonight and then have to wait a long time. It might be worthwhile to come to the next meeting when he's here, and if he's not here, we could talk about it then, and then he would be there for the following meeting.
Well, that certainly is entirely your call. I mean, you know, we received your letter and your input, and the board appreciates it. And frankly, I think it's well drawn. I think there are a lot of components to it which can serve as a good core for structuring what that may look like.
Right.
Number one. Number two. So I want to thank you for that. I think, speaking for myself, based upon what we saw last time and based upon in looking at the material further, that I have an actual interest in going to the site.
Okay.
It's a unique enough property, it's a unique enough size of land, it's a large plot of land, that I think it's important that the board has a very clear understanding of where you run your business, where your farming business is, where your septic business is, where the equipment is, where it is not. Because as a component of the conditions, I think we're likely
I hear you.
to draft, you know, from a viewpoint of being enforceable in the future. We don't want to be in a position where we say, well, yeah, he can have 3 trucks wherever he wants. I'd rather know, because frankly, I live out towards your neck of the woods myself, and I drive by your driveway, but that's all I see. Your driveway is like my driveway, you don't see my house, but you have a lot more behind your driveway than I have behind mine. So I was going to suggest that the board consider a site visit, and that would be an opportunity for the board in entirety to visit the site with you and have you basically walk us around and say, you know, here's where this is, here's where this is, here's where we did this, here's where we do this. So that's one issue. And if we don't do that until December, that's fine. But to be candid with you, again, speaking personally, if anything like Buffalo shows up around here in the near future, I don't want to be traipsing around anybody's lot, let alone my own. You know?
Well, as I said, I don't think I'm in a difficult position with the building inspector any longer.
I agree.
So my instinct tells me that it would be more valuable for you to have the site visit, and then we come back and we can talk about the conditions and talk about them now in the abstract. So
Right.
my instinct would be don't introduce no evidence tonight, just continue it to the date certain, and then have, can you have a site visit before then?
Yeah, I think we can.
Yeah.
Sure.
Sure, that's right.
Yeah, it's up to, I mean, the board can determine for itself when we can all identify a site time and connect with you. We
Yeah.
can come up with a couple of times that might make sense for us so that we're not just nailing it at one time. And in my experience in the past is a site visit of this nature might take, a half hour to an hour and a quarter, maybe an hour and a half, depending upon, how much conversation is involved. We have some, we have a plot plan, and we have some pictures, but,
We might want to incorporate a plan into the decision. I understand where you're coming from.
yeah.
Where we could identify things, right?
Yeah,
Okay.
and that's, and as I say, your suggested conditions, in many ways address a lot of the components that we would want to be specific about.
Okay.
We won't tell you what you can wear, but it'd be something like that.
Okay.
So if you.
I think
are
it's
you-
better, because otherwise we're in the abstract, and I think a site visit would be helpful, and then we can incorporate what takes place, and we can have a better discussion at the next meeting. So-
And that, and candidly, I'd like to have the chairman's input.
Yeah, and
His role is an important one. He has a lot of history in the town, and he knows, and I think we're all looking for a way that this can work, and we just want to make sure we cover all the bases for it.
So we would look to continue the meeting, is it December 18th?
Yes.
Is it to December 18th, and not open the meeting tonight for purposes of any
Okay.
evidence, and you can schedule the site visit, and if I need to sign anything to extend, I can do that. I did send the material, by the way, to the building inspector as well, if you may have
Yes.
seen.
Yeah, no, that's fine. Yeah, I think from our conversation with Ken and certainly his public comments that his interest is not to, as he said, he didn't actually issue a cease and desist. His issue is not desirous of doing that. He's really just interested in addressing some of the questions that were brought to his attention about the nature of your home occupation, as it were. We will probably know in advance of that hearing whether or not Chairman Thurston will be present. So we could alert you to that fact if we knew, and then if you just wanted to continue it, you can produce you can send it. Is that okay with you?
I'm in Ipswich, so it's not a problem.
One question.
Yeah.
I mean, is there any emergency that he's gotta move or anything? Is that nothing?
No, apparently not.
No,
We're okay.
No, that's what I was looking for.
Yeah.
Is there something
No,
on the
Yeah,
far
right.
side here that
Park is this.
you need some action on right away?
I mean, personally, not, you're gonna be out for 3 4 months.
Well, I know, I'm concerned about that. Well, but that's a bridge we cross when we get there.
So what are my extra days am I gonna ask for? Right, because I wanna continue the meeting
Continue to
as
December
well.
18th meeting.
I've got that, and then I also wanna extend the time, right, for making the decision, or do I have to do that?
No, you don't have to.
I'm
You
okay
have
with
to do
that?
that. Yeah.
Okay, so. I think then I probably did too many
Okay.
times.
That's
Thank
good.
you very much. And, yeah, there are animals out there, so you wanna give them some advance notice so that they can set that up.
We'll pick a time and Lisa will be in touch with you. Do
They
we have a
sick,
phone
they
number?
sick their dogs on the lawyer, I'm sure they won't do
Yeah.
that on you, but
We'll
you
bring
can see,
a
you
bow and
can
arrow.
understand why. Right.
We'll bring a bow and arrow.
All right, we'll see you in December. I'll check in with Lisa, and we'll find out what's going on.
All right, thanks for your patience.
Thank you very much.
Marion Way, we have a continuance.
We have a letter from them.
We have a letter from John regarding Marion Way dated November 18th, which is 2 days ago. Raleigh Zoning Board of Appeals, kindly continue the public hearing from Ryan Way to your December 18th, 2014 meeting. Signed, John Dukulis. We have to vote to accept that? No. Okay. So that hearing is continued.
Yep.
Good thing we didn't build the houses, they'd be rotten.
So we're actually ahead.
You're doing pretty good.
It's easy.
Keep moving.
Were you on
Don't
that?
stop now.
Were you on that?
On the previous one for the Blairs, where I wasn't here last month, what's the
coolest,
central issue?
The basic.
They have septic
Were you on it from the
service
beginning? You
business,
one of the four.
they're
This-
being told to
you
shut it down or
and me
not have it there?
And Tom and Don.
He has,
And I'm going off.
he has asked the
My
board
5-year
to
term
designate his
expires
septic business
next
as a
July.
home occupation.
And I'm
There's some
going-
question,
and I'm
number
going
one,
off.
as to whether or not
As
it's
home-based
purely a
business?
home-based
I'm
business.
going off. I've been
Because
on
it may
here.
be,
I've been on
it
here
certainly may be,
54
first of all, is it a
years.
home-based business?
And my
Secondly,
problem is
is it,
my
you
memory.
know, is it a
I
much
read
bigger business than he is
all
suggesting it
this stuff.
actually is?
I read it.
He also
I can't remember a damn thing about
has
it.
presented the
I do
board
that all the time.
with information
Don't
to
feel bad.
suggest that he is actually
Yeah,
a
but I can't
farmer.
read my,
And
I
his
can't,
farming,
Oh, you read it when it comes in, I
his
don't.
farming
I can't-
designation
got
is
nothing
based
going
on
on.
I
his
can't-
ability
I
to
can't
Nobody
produce
I used to,
Yeah.
mulch.
I used to.
He has 61A designation on the property, so that's
They're
valid.
doing it.
And,
I do the same thing.
however,
Yep.
there are a number of issues concerning the size of the business that have to be, we have to look at closely. Really whether it's a valid home occupation or not. And in conversations with Don, he brought up a point which I think is very interesting. And that is that in order for a farming business to be considered truly a farming entity, 51% of the products used in anything it farms have to come from the site. Now, if one speculates that his business is a septic business, we all know that in the construction of a septic tank today, that they don't just dig a hole into a septic, they do the field, well, they excavate dirt. That dirt has to go somewhere, because then he puts in sand, and he puts the fill on top of it. He doesn't always able to use all that, so it's not inconceivable to think he takes that and moves that. We have to look at that. So all of those are elements of really where that case has to be looked at. And the reason I want to suggest we go see it is because it's a huge, it's 13 acres. So there's lots of space for all kinds of things to happen here. And he's doing a lot of things there. And if we condition it, I think we need to know what we're conditioning and where, so that Ken or somebody else in the future knows exactly what we wrote down. And it's not unclear.
I thought, I mean, you need 5 acres for farms,
Yeah, he's got that.
and they can do basically anything they want
Well, they,
under the agricultural.
well, they do have that capability, but apparently to maintain the designation, which again, all he says, he has some animals, but he's not actually suggesting he earns anything off the animals on site. He's suggesting he makes money off the production and sale of mulch. And the production of that mulch, in order for his designation as an agricultural usage to be valid, is that 51% of that mulch has to come from.
I heard that, he could have logs and cut logs.
Well, that's fine. He
You know what I
and he
mean?
could have done some treeing and lumber and stuff like that. But is it? I mean, is that something that
And a
he
lot
can
of
do
time-
forever? Off 13 acres? I mean, 13 acres is big when you have an acre, but when you compare it to 100
Oh,
acres,
yeah,
it's
no,
tiny.
they're not houses up there.
But the under 40A, not the bylaw, 40A, it defines what you can do for agriculture, viticulture, it's got them all defined. And this home business is not in that. That's why the home business is ancillary. to the, it's not part of the agriculture, it's agriculture as a farm and a home business in addition to that.
Right.
And so I think, I'm trying to think, is that section 6 of 40A?
I don't know.
Might be 3, well, anyway, be that as it may. I don't think that the septic is part of the agricultural business. It's in addition to it.
No, but it's a supplement for them to make a living,
But
which
it,
agriculture
yeah, I'm not sure,
has,
yeah.
they all do different things.
Right, but
That's all I mean.
that's why you can cut trees as a farm without any permit. I don't think you can have a home business that's not agriculture without a permit.
Oh, a permit, I mean, I know you need, yeah, but there's, I mean, if you go look at different farms, I mean, they do everything. I mean, you can have logging, you can have millwork, you can have milking cows, you can have chickens, you can have,
Right.
you know, and you can have a pumping to go out pumps, septic, so I've seen farms that do that. You know? Not that, just bringing it up.
No, it all has to be discussed.
Right.
It's all gonna have to be reviewed. But we are gonna need to try to find a time for a site visit, so I don't know what kind of schedules exist here. And I don't know whether we wanna try to communicate back to her via email and try to plug some windows in there, or
Yeah.
you set some times and shoot out
I'll reach
emails and
out.
let us choose.
I'll reach out next week.
And then we'll identify it.
I'm not available next Thursday, I'll be in the stuffing business.
Yeah,
Any other time I'm open.
I will be lucky if we, I wouldn't say next week will happen, it would be the following week.
Yeah, that's right, the holiday.
Are you rolling down? I got one. I got whatever. I'll try something.
No excuse.
Have a holiday cocktail, so it's like the through here. I just want to alert you that our chairman, Don Thurston, is not with us this evening. He is unavailable due to some medical issues dealing with in his back. In his absence, the board has voted me as clerk to serve as chair for this evening. It's a one-time event. We have adequate membership here. Your case hasn't been before us, so we have full-time members here available to hear the case. If Don is back next month, he'll resume his normal position. If not, there will be a similar action, and I don't know whether the case will be decided tonight, whether it will be finished tonight or not, but that's the board's call. But just so you know, that's the status, but otherwise we're fine. We actually have a few minutes on the docket, and it's normal protocol to let anybody who's gonna be here, be here.
That's a big deal.
Well, that must actually, that must
This where he wants to go.
yeah.
So there's an ad,
So this is a change to another one, not from one to another.
Yeah, so there's nothing in there now, but yeah, that's the, from not conforming to it. I don't think we can do that.
That's been lost. Very, isn't it? It's useful.
We can't do that.
What was it before, what was,
It's the golf place.
on the boat place?
Canoe and kayak.
Before the canoe place, but there was a machine shop.
Yeah, I think so. Our case would show, I can't remember, but you might remember.
I started one threshold.
children's snows too.
And the other one could be windows. It used to be the printing place. No, that's
Oh, no. It's 383?
1955 to 82. It was a printing. You know, like a
Yeah,
large
you see that.
machine. And they put
This may help. There's a little history of the use of and dates.
Okay.
Okay,
You got
from
it in there.
inception, from, you have that? Okay.
You got a list on it.
Yes,
You got a list on the packet.
yes.
I didn't know if you had that or not.
You know where it is. So 383 Main Street.
Yeah, you know where it is.
No, I can't place it. If it's not in the thing,
It's the one set back in. It's a one that you set back in. It used to
Right.
be the canoe thing. And there was a machine shop before that.
Right.
And that's where the printing place was originally. 1955, printing place.
Yeah, we did.
They have all the different uses. You know, it's awesome.
Yeah,
Unbelievable.
it is amazing. What was Maple Corporation? Were they machinery shop?
It was the predecessor to Alden Rowing Shells, the same thing Alden acquired.
with Alden Rolling Shells, yeah. I remember that one.
You should remember the printing place, I remember that.
Yeah, I remember the printing. Just trying to locate, my problem was locating where I was physically on the, what part of Main Street. I mean,
Oh, I get you.
the location was all. Because there's been, down the road, down the street of the ways, there wasn't a children's place.
That's exactly where it is. Children's place, did you say?
Yeah,
Yeah, that's,
yeah, but that isn't where,
yeah, that's. the-
that isn't where,
This is where he wants to move into. The children's place moved out.
There's a number of children's centers on Main Street.
Yeah,
There's
there
three or
have
four.
been.
Yeah.
The one down by the railroad bridge also.
Yeah, but we're just talking about the one where the property is. That's the
Right,
one
but
we're talking about.
I wasn't sure whether he was actually pinpointed that location.
Well, there's one children's center that I was thinking about, is if you come down Cross Street, where Cross Street hits Main, and if you go to the right,
Oh, right in the house, right there,
across
there
the
used to be
street
one right there,
there,
yeah.
there's a children's center.
Used to be.
Used to be.
Right.
Is that the one?
No.
No.
Okay,
Yeah, you're up left.
This
take
is-
a left.
Take a
Well,
left
what's her
and
name,
not across
Thomas?
street, take a left off.
That's the one.
Couple houses on the right. Kent's buildings in there.
All right, gentlemen, I'm gonna go forward. We'll mine what we need. I'm gonna take a moment and read some information, this generic information for everyone who's here and anyone who might be listening. I'm gonna open the hearing for case 1506 from, I always mispronounce this, Maffei Plumbing and HVAC for a special permit at 383 Main Street. Public hearing will proceed in an orderly fashion. I ask for cooperation in the following procedure. Everyone present will be given an opportunity to be heard after the application is presented and the board members have asked questions. The secretary will be recording what is said. Therefore, when you address the board, begin by stating your name and your address. Speak slowly and clearly. Only one person will be allowed to speak at a time. At this point, are any conflicts of interest with any board members?
No.
Nope, okay. The public notice for this application was posted at the town hall, sent to a certified list of parties in interest, and was published in the town common on November 5th and November 12th, 2014, and reads as follows. Public hearing will be held at the Town Hall Annex 39 Central Street on Thursday, November 20th, 2014, at 8:15 p.m. to act on an application received October 20th, 2014 from Gregory Maffei, 89 Turnpike Road, Ipswich, Mass. Applicant is requesting a special permit from the Board of Appeals for the change of a non-conforming use under section 5.2 of the Rowley zoning bylaws. The property is located at 383 Main Street, Rowley, Mass. Property is in the outlying district and is shown on the assessor's map 27, lot 57. At the public hearing, members of the public may ask questions and present evidence that supports either the approval or denial of this petition. The purpose of the hearing is for the board to hear and consider the pertinent facts relating to the application and to approve with conditions or deny. Before hearing from the public, the applicant will be allowed to present their case, and then board members will be allowed to ask questions and or comment. Before I will go ahead and read the application into the record, so we know what we're talking about. Then Ms. Maffei, you'll have an opportunity to address the board specifically. And I will make reference to all letters that the board has received from other boards in town. The application itself, the applicant is Maffei Plumbing and HVAC, 89 Turnpike Road, Ipswich. The owners are John and David Kent of the property, 383 Main Street, Rowley, Mass. 01969. The applicant is a lessee, to be a lessee. The application is for a special permit or a zonings from requirements of sections blank, but I believe we're looking at 5.2, is that right?
Yes, that's what
It's my understanding.
Okay. Of the Rowley zoning protective bylaw. Again, the premises are at 383 Main Street. It's in the outlying district.
Yeah, that's where they would have them.
The parcel ID is on book 8563, page 23. Parcel ID is 027-057. The description of the proposed work is office accounting, parts and storage. Has a variance, special permit, or other zoning relief ever been requested for the premises? The answer is yes. Reasons for the request: Ken Ward, our building inspector, Town of Rowley, deferred us to the ZBA for approval. Signed by Mr. McFay is the owner. The board received several memorandums from other departments. We also have a certified abutters list that was presented. We also have received a plot plan showing depicting where the site is on Main Street. And we have a specific plot plan of the legend of the property specifically for reference. We also have a permit and license clearance form. And we also have a historical listing of companies that have been at the location dating back to 1955, as well as our prior decision, A606. I don't think, and 95-06. So we have a couple of those decisions there. Essentially, the memos from our fellow boards do not express any concerns, objections, or questions with the application. Only the planning board raises a query about the use and the time frame of the current and former use relative to an issue that the board has to consider. And there's also the memo from the building department in which the building inspector indicates that he's referred the applicant to us. However, because he's concerned about the grandfathering of the property having left in 2014, since there was a question about whether or not the former use, now vacant from that site, Rowley Children's Center, was a conforming or non-conforming use. So those have to be addressed in the conversation. Mr. Maffei,
Yes.
it's your floor.
Okay. I would like to move my business there. I moved to Ipswich about a year and a half ago. I was growing out of my home, and I think, as you know, I came down here looking to do something else, and it wasn't permitted, which was fine, so I moved to Ipswich. Before that, I had contacted the Kents to see if they had any space available, and at the time they did not.
Did you move the business? Are you still a resident in town?
Oh, yes.
Yeah, okay.
Yeah, I still own that property, we live there,
Okay.
but I moved the business out of there because it was getting to the point where I didn't stay there. That being said, the place we moved into, Ipswich, isn't ideal. I mean, we're down on 89 Turnpike Road, which is commercial, that's right on Route 1, right next to United Pipe. We're in there on the second floor, and we have some storage out back that we're able to use right now. This property that the Kents have, John gave me a call saying that his tenant was leaving. Was I still interested? And I am. It gives me the space that I need to warehouse the parts. We do a training for our service people once a week, so it will provide us the room we need for that. It's all on one level, which will be nice to be able to control it that way. And again, it would be a good location for us to go to. I like staying in town. I preferred to stay in town, but I looked all over the place. I looked down at Dr. Smith's building and was looking at that for a while, but the owner of that and I couldn't come to an agreement on that. And there were some issues there with zoning as well that we were going to address, but we couldn't come to an agreement there. So I'd like to come back to town. We're a good company. I mean, we support our local businesses and town people, and we'd like to be back in town. And I think it's a great location where we can run our company very well. Again, we're not a construction company. We're a service-oriented company. We do service repair and installation, residential. We're not a commercial contractor. So I think it's kind of a good fit. So. And then I'm assuming that you have some questions for me, so I'll
What part of the property are you talking about, the left part of it?
Can you kind of show us?
Sure. I mean, we have maps, I mean, there's Main Street.
There's Main Street, so it's this right here. This big building here. Right here, there's a loading dock right here.
Yeah.
There's the stairs to the old, that would be our main staircase going into the building. There's another entrance down here. So we'd be occupying this space here.
Where's all your trucks and stuff in the park?
The trucks now go home. I mean, there may be 2 or 3 at most that would be possibly left overnight. There are 4 to 5 office people each day that come in and out. We have plenty of parking here to do that. And again, anything that we need to do, if we do need to leave trucks, we can go out back. There wouldn't be.
That's an aerial view there, Tom.
Where do you, Deerfield Lane is a public way, right?
Yes, private.
Well, it's a private, but I mean,
I think it's a 2-lot subdivision.
so, I mean, I'm guessing you drew these on here to depict the car, and I can see a vehicle there, so I can see that you could certainly have about 4 to 5 vehicles at least, as you've drawn here. Is this the parking where all the parking would be for that tenant, right in front of the building? So, I mean, I'm reading this as yard grass, so I'm not thinking you're gonna actually put anything back there. You're not gonna drive and put anything back
No, we're
there.
not planning.
You can't, right?
Well, I know.
There is driveway and parking, parking up there as well.
There is?
There's a driveway to the right of the building that goes out.
On this side here.
Oh, it comes up here?
Yeah.
What,
This is all pavement here. This is another warehouse here.
oh, I see,
And-
off this
and
pavement?
Yeah, and this comes up around this way.
Oh, it's not showing with the trees there on that view.
Right.
Yes. And how many trucks, are they your trucks, or do your workers own the truck, your trucks?
They're all mine.
How many trucks do you actually own?
7.
7? Oh, great. And 1 or 2 would be there?
Like tonight, I think there's 2, and other nights there's 1. Sometimes there's none, depending on what they're doing. A lot of the employees live locally, so they take the trucks home with them. But once in a while, they drop them off and their wives pick them up or whatever, because they're off doing other things, so.
What are the normal hours of business?
I'm usually in the office by about 7 o'clock in the morning, and then usually everybody's gone by 5. And it's usually Monday through Friday with a half a day Saturday we work. We do obviously have 24-hour calls, so you may get a truck coming down there to pick up a part or something in the middle of the night if somebody had no heat, but.
Right.
Greg, when you say trucks too, they're service vans, correct? They're not,
Service vans.
Yeah,
I think
service
everybody's
vans.
seen the
Yeah,
alligators,
okay.
and
Yeah,
they're
Yeah.
quite noticeable.
I think the biggest truck you might have is a cube truck.
Right,
Yeah.
yeah, there's nothing bigger than that.
Okay. Any other operating questions about this?
Well, not operating questions. I mean, Ken Ward's memo
Right,
is a pretty big problem, but
right, we have to look at that.
What is it? I didn't think I saw that.
Well, I think given the fact that it works for you, that's fine.
Okay.
And frankly, I don't think any of us have an issue with the company being there.
Okay.
We'd love to have you here. We know you're a resident in town. You came to us last time and you didn't choose to ignore us.
Right.
You paid attention and listened and did the best you could, and you found a solution and it works. And
Right.
we're certainly cognizant of the fact that you didn't say,
Right.
well, tell them to go away. The issue that comes before the board in any matter of this nature has to do, and I think you may have some sensitivity just because you had to run into it in the past, is what the zoning board really deals with is non-conforming situations, whether it's a structure, whether it's a lot, whether it's a use. And the zoning board's authority usually moves into trying to find a solution for granting a permit or a variance for a condition that's out of the ordinary. Most ordinary things go to the planning board, and you're fine, and if they say you're fine, and you go to Ken Ward, you're set. In this particular, in the prior instance of this particular property, and it exists in others, when a non-conforming use, you know, whatever that use happens to be, for a given district, changes, that's something that has to come before the zoning board. When when a non-conforming use disappears, if it disappears for more than 2 years, okay, the non-conforming designation for that site goes away. And by the zoning bylaws, we can't have, it goes to a less conforming use. It goes to whatever a conforming use would be at that location. The board doesn't have the ability to take a conforming use and turn it back to a non-conforming use. We're limited, we don't have the authority to do that, number one. Number two, the board also in Rowley does not have what's called a use variance. A use variance is a tool that some zoning boards in the Commonwealth have, which a town can use, a board can use, to say, this is an odd situation, and even though this use is something that isn't allowed here, we've talked to everybody, we've reviewed the nature of the business, we've determined that it's not going to be a problem, so we're going to give it a use variance for this site, for this business. Okay? That's also a tool we don't have here in Rowley. Candidly, I hope the town thinks about adopting that, but it hasn't to this point in time. Part of the issue that comes into play right now, because when we all saw the application, our reaction was, makes sense. It's okay. We know Alden Shells was up there, and we have a fix for what's up there. The last use that was there was the Children's Center. Now, Ken Ward has, in his memo, said that the property has been used as a non-conforming business uses up until 2010. He says, however, from 2010 till 2014, when the Rowley Children's Center took over, this use is allowed in all districts. Now, if that's accurate, okay, what we had is a conforming use go into a space. That means the last non-conforming use left that space in 2010. At no fault of yours or yours, a non-conforming use went away in 2012, okay? Which would mean, therefore, that the grandfathering, as Ken says, the grandfathering of the property went away in 2014 because it has been more than 2 years since it was conforming. Now, he notes this is why Greg was told to come to us. Now, I'm having difficulty, and what we have to try to find is how we can interpret the Children's Center as a conforming and non-conforming use. I have not to date, because when I read that memo, I said, wait a minute. There aren't a lot of uses that are in every district allowed. The Children's Center is admittedly a pretty soft use, let's face it. You know, it's quiet, it's contained, it's usually not something.
Quiet.
What's that? Well, comparatively.
A lot of time out.
Yeah, right. Hopefully, but relative to normal commercial uses, it's quiet. However, when I look in our bylaws and I see all of the uses that are permitted in all districts, I don't see anything that I can directly construe as a children's daycare center. I don't. Now, that's why there's other board members here. Unless we can conclude that Ken's reading is inaccurate, I don't know. I don't see where we go here, frankly, because I don't have a tool to give you a use variance to say, fine, you know, it's a good business, we'd like to have you here, you're a resident, you're a taxpayer, this has happened a couple of times, where we had local residents who have good businesses in the town that we would like to try to accommodate, and we've been prevented from doing that because we don't have the tools to do it. I'm not sure, again, I'm not sure that Ken's reading is accurate, and if the board concludes that it's not, and it's just another non-conforming use, then it would be my opinion that with a normal amount of conditions for things like trucks, none of which strike me as being difficult issues to deal with, from what you're saying, that we could come up with something that would allow you to be there and grant you a special permit for that. So, can
We're
you...
almost punishing a person that owns a building that rents it out.
Well,
You know,
well, no, that's true, but it's not the owner's fault by any means. That's why I say that the nature of his tenant is the nature of his tenant. I mean, I've spoken to other owners who have properties where they stop using it in a commercial capacity, and they want to reinstitute it as a commercial capacity, and it's their property. But because it was stopped, and they want to use it themselves, but because it was stopped more than 2 years ago, they can't. They can't in their own property put that in. That's a component of the bylaws. So I don't know, you know, now again, I submit to the rest of you, show me in here, under our uses, something that allowed Ken to conclude what he did. I can't find it. When I look at this, when I look at uses permitted in all districts, 4.8, cemeteries, okay? Municipal buildings and uses, agricultural, horticultural, floriculture, and viticulture, provided that such shall use be limited to parcels of land containing at least 5 acres, okay? Uses of land or structures for religious or educational purposes on land owned or leased by the Commonwealth or its political subdivisions, or by a religious sect or denomination, or by a nonprofit educational corporation, except as provided in MGL, and provided further that if new or additional off-street parking is required, a site plan has to be approved by the planning board. I don't see it falling there. Personal wireless service facilities, it's certainly not that. Activities accessory to activities otherwise permitted within the district as a matter of right, which activities are necessary in connection with scientific research or scientific development or related production, whether or not on the same parcel as activities permitted as a matter of right, subject to the issuance of special permit by the Board of Appeals. Well, it's certainly a child care center, it's not that. Conservation areas for water plants and wildlife and dams, it's not that. Accessory structures and uses which are customary, incidental, and subordinate to a principal use permitted in the district, including storage trailers for temporary use and where dwelling units are permitted home occupations, notwithstanding the provisions of this paragraph, special permit from the planning board is required for any building that is accessory to a dwelling unit that is more than 1,500 square feet. Well, it's not that. The only element of that statement that is a long stretch in my mind is when it says accessory structures and uses, you know, where dwelling units are permitted and a home occupation, but you know, that's if you consider a child care facility a home occupation. And I'm not sure I would consider a child care business a home occupation, you know, unless it's, you know, one of these sanctioned, you know, you're allowed to daycare centers where you can have 6 or 7 kids, and I know the child care center had probably closer to 15 or 20 at least. It was a fairly substantial, I mean, my son and daughter was there when she was over in the Congregational Church 20 years ago almost, kind of thing, so. And she was busy then, and she was talking to me about looking for space, so. So those are the areas that are all permitted in all districts. Now, even when I go into the outlying district, you know, I look at the things that are permitted there, The outlying district is intended as an area of low-density residence, okay. Following principles uses are permitted: single-family dwellings, okay. Conversion of buildings to accommodate more than one dwelling unit, okay. Townhouse dwellings, okay. Accessory in-law apartments, okay. Agricultural, horticulture, floriculture, et cetera, okay. Fine. The following is permitted, provided site plan: large-scale solar photovoltaic installations. The following is permitted, provided special permit by the planning board: country clubs, day camps, and other non-profit recreation uses without overnight accommodations. B, a landing field for the non-commercial use of residents of the lot on which the field is located. I don't know what that means, what a landing field means. To me, it means planes, provided there are no hangars and no repairs. Wow, what an odd use. Country clubs, day camps. Is a child care center a day camp?
It's a non-profit also, so,
Yeah, but I don't think she's a nonprofit.
no.
You know?
It was, she was, my name's Don Kent. We used to own the building. And she was nonprofit because she only had like 3 kids and she was losing money every day.
Yeah, but that's why she was a nonprofit. That's not a 501c3. If you're a legal nonprofit, that's different from not having enough business.
Wasn't the plan.
Well, it's just, may I say that it's just,
I'm sorry?
in 1982, when they passed the zoning, there was a member of the zoning board who is deceased now, that stood on my front steps of Rowley Printing, which is the big 25,000 square foot building in the back, and continued to push for the 11 businesses that are between Railroad Avenue and Cross Street. There's 11 businesses there. And they're all gonna have the same problem if this, I mean, the children's center was there, and it's basically offices. And basically, I think what Mr. Maffei is looking at is basically offices for his accounting and storage for parts.
Yeah, I don't think
And it's,
I don't think the issue for me is the actual nature of the use of the companies. Because Olden Rowing Shells, I mean, he had some office space, but there was also some manufacturing. He had to produce the damn thing, right? The dilemma, which I can't find the dilemma that Ken Ward points to, is that the children's center use was a conforming use there. If we can conclude that the children's center was yet another non-conforming use, now frankly, she should have come to us for a change in non-conforming use, because we never saw her. She never came here. So technically speaking, there's a question about whether or not she was a permitted use, because she wasn't. But the use of the such, and that's another subject.
Well, if she never came to us, then we didn't change anything.
Well, no, but the if that's the case,
Then we
then
go back to what,
well then it did, well that yeah,
Could
but
go in there.
but then it ended in 2 years. Because Alden left in 10.
It's been vacant.
Because technically, no, she was in it, but she was not technically certified as a non-conforming use there by this board.
Well, when did
14.
210, and she left in 214. What we're saying is she never came to this board, so we never voted on anything.
right, but that doesn't change, I mean, the fact that this board didn't vote on anything
Well, was
is
she
not
in?
indicative of what the use was.
No,
But
she
does the
was
use
in
have
there
to
without-
be permitted to be considered a
Wasn't
valid
permitted.
use?
So why can't it go back to the status that it was? And then these guys could move in.
Well, it does go back to the status. If we do that, it's still technically speaking that use ended 2 years after they left. Because if she was really a smoke and mirror company,
But
their use ended 2 years after. So I think we have to determine whether or not, as Bob is suggesting, it's irrelevant whether or not she came to us, the use was what it was. And I can't see where the use was a conforming use. I wish Ken had either elaborated, perhaps he has misspoken in his note, in his
but he
memo.
must have thought they could go in any district, so he just okayed it probably.
Maybe, it's very possible. I don't know, did she have to do much there when she
There
went
was
there?
fire department was involved, Ken was involved, the facility was inspected. I
She
mean,
did some electrical work,
yeah, there was.
Fire alarm system got installed.
exit signs,
All
that
sorts of
type of thing,
Yeah, he must have assumed, you're right, he must have assumed it was a valid use.
I would think, I don't know.
But I don't see it as a conforming use, and I can't even find,
Maybe the valid use was treated as if it was in someone's residence, as a number of these daycares are, it's home-based, and you may have construed it to be similar to that. Folks that have 3 or 4 or 6 kids that they take care of in their
Yeah.
own house.
They still have to be licensed.
what you would think. Those are,
I'm sure
they're
it's
supposed to be
licensed by the
licensed too.
Right.
She was checked, the board of health checked it because she had to have a refrigerator that had to be so cold and all that.
Yeah, I mean, I'd really like to know why Ken said he thinks it is conforming, because I agree with your reading of it. My reading is the same as yours.
Okay.
I don't see it as a conforming use.
Now, is there a state law that overrides the town bylaw?
I don't think so, not for daycare.
I-
Very
you know,
strict on that.
That's the only thing that could be, but I don't even see, I would like to have seen that even stated, in the absence of it being stated anywhere as an approved use.
Well, I'd like to ask Ken to clarify that, because, I mean, he is the zoning enforcement officer. I'm not gonna assume he's
She
wrong.
isn't enforcing.
Mr. Chairman,
Who is?
Ken
Really?
gave that same notice when Alden Rowan Shells went in, and also on MDX Industries. He gave that same notification. He didn't want to be the man that made the final decision.
So with the 5 or 6 occupants that we've shown there in the paperwork, at every turn, it's been in front of the building inspector and, trying to go through the proper processes.
Yeah, I mean, I agree, but I'm with you, Bob, about, I wish we understood Ken's feeling, but I don't see how his feeling can be based in anything that we have access, that we need to rely on. I mean, all the information that you've submitted, some of which we know and we created ourselves in granting permits in those locations, in the location, suggests that it would be there, and, you're right, she has to be licensed, which means her use has to be a licensed use, even though the town hasn't recognized it by special permit.
Well, my only point there was it's not a traditional home occupation. Because if she has to be licensed, then it's not gonna fall in the definition of
Yeah.
a home occupation.
Right. Well, I just think the only dilemma that we have
Home
is,
occupation has to be, they have to be licensed too.
Not all of them. You have to look at what's defined as a home occupation.
yeah,
If you're
no,
running a daycare?
but Bob's saying, but in general, home occupation.
Okay, I'm sorry, I thought you were talking to daycare.
But I don't, I don't think the issue here hovers around
Well, it sounds like you're
an
gonna ask
interpretation
Ken.
of this as a home occupation.
Can we continue this?
I think let me ask the applicant this, though, you have space, you want to be able to see, it could be clarified simply, unless if the board feels we should get it clarified. We can get a letter from
That's what I thought you were
Ken.
leaning to.
Well, you know,
Well, I was leaning to.
with a clarification, you would feel more comfortable in granting.
Well, if somebody says it's an allowed use, before you go and say, no, you're absolutely wrong, which is what we have to do.
Gotta find out why Kenny said it.
I mean, I think
Basically.
Mr. Kent may be right, because I'm thinking what Ken, because Ken says here, the grandfathering went away, so you gotta go talk to the ZBA. Well, we can't fix grandfathering that goes away.
Right.
So why would he
You're
send
right.
them to us? If he meant to say, listen, this is a change of a non-conforming use, but in order for that to be approved, you have to go to the ZBA. Absolutely.
That makes sense.
And Ken saying, not my call. If they want to call it, which we can do, and I think we would do, that would make sense. But so I don't know whether this is just a miswritten memo, or whether there's basis for his statement, but I can't find any basis for it.
If it's hard to-
Well, the only thing we can do, does the board, do I hear a motion to accept the application as submitted and to draft an approval for
Yeah, I agree with that, that makes sense.
it? You do?
Yeah.
As submitted?
Yeah, as submitted, then you go to Kenny to see what he's,
Well, he's talking about approving it
is.
before the
Period.
clarification.
Before the clarification.
Oh, no.
I personally don't have a problem with it, but I can see you have a good question with Kenny, so I think it sounds like you should ask and find out what his, clarify.
I mean, I think if that's what we want to do, I think we're going to have to continue the hearing. We have to get a clarification, and once we have, get Ken to give us a written clarification. I don't want, hey, what did you mean?
Because I
want that for the record.
Well, can we see it as well then, before the next meeting?
Oh, of course.
Because I didn't see this before the meeting, and I kind of went through some similar things last time. I just don't want to go down that road. I need to know what to do.
Right.
The Kents need to know what I'm doing.
No.
And I have to give 6 months' notice to get out of the lease that I'm in.
Yes.
I've already pushed it 2 months. We're going on to a third month now, so I just appreciate, something speedy if we can do it.
We don't feel as though what we're proposing here is any more detrimental to the neighborhood, to the building, to the facility. We want the tax revenue maintained in town.
Yeah.
We want the activity maintained in town. I mean, David and I own the property, and we both live in the neighborhood, within a stone's throw of this facility.
Yeah.
We maintain the facility,
Yeah.
That's not the problem though, because
I understand.
if Ken is right,
and you gotta.
our permit's invalid. So therefore, to give you a valid permit, we've got to say he's wrong.
So,
And before we say he's wrong, I don't want to assume he's wrong. I think he's wrong,
okay.
but I don't want to assume he's wrong without at least asking him the question.
We may not be right or wrong, I think.
No, he's either right or wrong.
I think what I've
No,
seen,
it all hinges on whether the daycare is an allowed use or not.
I think he's actually trying to be like Switzerland. He's trying to remain neutral and pass it on to a higher authority.
But he's made a statement that the daycare was an allowed use.
I think that's what he,
Because
we've
in
seen him
years
do
past,
before.
it's always,
He's done
go
it
see the
a number of
ZBA.
times.
Well, and frankly, as I said with the wording, and candidly, we have in conversations with him said, listen, if you don't want to make that call, that's why the town selectman has a board like this.
Right.
That's what our job is supposed to be, to try to find ways to help our residents do things, instead of one person then going, oh, I made the wrong decision, now I pissed them off, I pissed you
I
off,
think
piss everybody off.
there's a track record here, though, of every variance that's been issued, or special permit that's been issued on this property, has gone to Ken Ward or to the building inspector first, and has always been deferred to you folks. Always.
Because he can't change a non-conforming
Yeah,
use.
but it's-
He can't do it. This is not the, if all it was changing from one non-conforming to another, he'd still have to say, I can't do that, you gotta go to the board. and the board would allow it at every time. He's thrown a much bigger monkey wrench into it. He said, you're not changing from a non-conforming to a non-conforming. There is no non-conforming to change from. It's a conforming use that you're changing from. If that's correct,
We can't do that.
then that's a huge problem.
Now,
And we don't think he's correct.
Right.
So,
Right.
so
what I think, I would be willing to say that probably, and we'll share it with you as soon as we get it, if Ken clarifies the statement the way I think he probably will, which is to send a new memo stating that the issue before the board is that this was a non-conforming use going to a change of another non-conforming use, then I don't think anybody has any issue with it. And I think you could assume that at our next meeting, there would be virtually no deliberation. I mean, we can pretty much, I think, the board could authorize the clerk to draft a document in preparation for an approval at our next meeting, so it wouldn't be another 30-day window. But Bob is actually right. I mean, we're not in a position to grant a permit that if someone outside of this room is concerned about, they could appeal, and if there's any grounds to what he's saying, everything would stop. You would not ever be able to rent it until it goes through the housing courts, and you don't want to deal with that. As opposed to just having the next question.
Greg Glenn over at 374 Main. Is this going to allow residents to say something if you move this on to another meeting?
Oh, sure, absolutely.
So it's
Yeah,
not
the hearing,
making a
I
decision.
mean, there's no decision's been
I
made.
don't have a problem with the business going in, but just concerns.
Well, then I would put them on the table then. Sure, stand up, please,
Oh,
let's see.
okay, thank you.
Yeah.
I've seen the business over in 133. The only thing I asked Greg if type of deliveries that we could expect, because I'm right across the street, changes in lighting that might happen there.
No.
Will it get any worse?
Is it bad now?
It's, you know, but it's not, I don't want to see it increase.
Okay.
And signage issues, we'll be seeing signs going up.
Only what they had out front there before,
Okay.
something similar to that, whatever conforms to the local codes.
Signage bylaws.
Yeah, the signage bylaws. Yeah. And then for deliveries, typically we get one UPS delivery a day and probably one other delivery from the supply house. You know, it's a box truck, a little bit bigger than mine, maybe a 14-foot box truck that would deliver.
How about dumpsters?
We would have a dumpster that would be out back.
never see
We're
it.
there now.
We'll keep them shielded, so.
Yeah.
not an issue.
I-
We have
I-
to live there too.
In fairness to any kinds of similar concerns that you might have, you know, we're happy to listen to those closely, and in cases past, typically the board will include a condition which will identify, you know, a dumpster is allowed, but it's only gonna be here.
Right.
So if it's, so that they can't, you know, if they get a dumb dumpster guy who throws it in their front yard one time, they call him again and get it out of there. Lighting issues, we can,
We have a lighting bylaw. but,
Yeah. I
He
mean,
just doesn't want it increased, so you can, you know,
yeah.
help.
Yeah, I mean, those things can be addressed. Traffic, that's why we were inquiring a little bit about how many trucks, when would they come, what are the hours? Because we would, you know, we would attempt to put some conditions in the location so that, you know, because we've had cases where guys get really, really successful, his business has grown substantially. Who's to not know he gets a state contract and he gets 20 more trucks? And he's got guys running 18 hours a day, you know, I mean, under our permit, if it's not clear, that could happen and create some problem for you, we wouldn't want that to happen. So we make those comments, we're glad you did, don't be afraid. Question?
You know, like the hours of operation.
Could you identify yourself?
Al Kolakowski,
Okay.
382, I live right across the street. I have no problem with Greg going in there either.
Okay.
So I want to make that clear. But the hours of operation, what would that normally, what does the board allow? I know what he wants, but what do you allow?
Well, I think the board tries to take in consideration the nature of the business when the business tries to run. He expressed what he thought his normal, it sounds like normal business hours are generally 7 or 8 to 5 or 6. So it's, a 10, 11-hour day, something like that, which, unless there was exorbitant amounts of, problems with that, I would say that would be probably agreeable to the board. It doesn't look like weekends are busy, part of the day Saturday. Probably something on that order.
Yeah, I mean, most of the work is off-site. We don't make any money if our trucks are sitting in
Right,
the
right.
parking lot, so we're out to customers' homes. So when I say that we're there half a day Saturday, it's usually a dispatcher and a phone answerer. They're sitting in the office answering phones and dispatching trucks.
The storage of copper and all that, the
Yeah.
old copper that's gonna
Yeah,
be
just
hidden so that they don't see
Yeah,
it.
most of that's going right inside. I've got the room now,
Okay.
at that loading dock to put everything inside. And like I said, the dumpster is the only other thing, that we would be.
As a neighbor, do you have any preference of time? I mean, is there something you're looking for?
No, normal business hours is fine, but the thing that just threw a flag at me is that I may have to go in there in the middle of the night to get a tractor, to get a unit up and going. I mean, I don't think there's anybody here in this room that wants somebody slamming a van door at 2 o'clock in the morning. I'm not saying it's gonna happen all the time. Sure. Believe me, my son's in the business, so I totally understand.
Yeah.
But nobody wants to be woken up at 2 o'clock in the morning for somebody to slip open the garage door and grab a basket, 'cause this happened one time before at the business.
Right.
And it was a nightmare for us. And it's never been like that ever again. I wanna make that clear. But I never want to see it happen again either. It's gotta be controlled. That's my only concern. I mean, as long as the building looks the way it looks now, with no banners and, there's a lot of businesses around town with always banners hanging off the buildings, and that's fine where they are, but please not
Your
across the street
backyard,
from
right.
us. You know what I mean?
Right.
Yeah, not my backyard,
Right.
not my front yard. My backyard has trees. I mean, that's my only
No, I mean,
concern.
that's something you gotta think of. I mean, you're in a neighborhood there.
Right, I mean, you're coming into a residential neighborhood, we're not moving into an industrial area. I mean, that's, we all have to get along. And I believe me, I wanna get along. I don't want any problems with anybody. But you have to be considerate of, maybe we live there, we sleep there, and live in bedrooms in the front of the house, so, that's it. I mean, good luck to you. I mean, you get in there, good luck to you. There's no problem. But I also don't wanna see 25 trucks out front either. Either way. No, I hope you do. I hope you have no
Ain't gonna make any money with the trucks sitting out front.
They
But
look nice, but they don't make money.
realistically, these trucks are billboards.
Yeah, well, they are.
You know what I mean? And that could be pretty unsightly if there was like 5 out there. There's a couple out there, that's fine. I have no problem with that. You have to be in business, and you have to be able to operate your business. And I totally get it. I support small businesses. I've always worked for small businesses. So I'm totally in favor of you guys, but as long as you could just consider it for people around you.
We can assume you don't want a livid sign.
Yeah, you got that right.
Okay, well, I think that's where we are. I don't think we can go any further tonight.
Okay.
We appreciate your interest, very much so. And we certainly appreciate abutters who are particularly concerned about it, and we welcome you to come back to our next hearing as well. And certainly, don't hesitate to put anything in writing. Keep in mind that, as abutters, that one of the elements that escapes a lot of people in our town is we all drive around and we see things that we don't like, and we go, who is doing anything about that? The town is really too small to employ people to do anything about most things like that. The only way anything's going to get done, when something reaches to a point where it triggers like, this is ridiculous, you have to put it in writing and put it in front of a board somewhere. That's what you got to do. We always encourage abutters, of any sort, talk to each other. We had a case last week where abutters couldn't resolve a property boundary for almost 10 years, and they finally came to an agreement on where a property boundary was, on land that was in the middle of nowhere. But it got settled. I mean, who cares, right? Am I on your land or not? Who cares? but it got settled, okay, and they finally worked it out. So I would encourage you, you know, as I said, Greg has always been good in front of the board, he runs a reputable company, you know, we're cognizant of that. He seems like a very reasonable person. I think if there were anything that remotely, you know, came to your attention at some point, I would just go to him. But if after some point in time, life doesn't happen the way you like it to happen, put it in writing, then a board like ours can respond to it. You know, if you say, geez, he says he only has 7, but I counted. You know, there are 14 trucks that go in and out of there. Put it down in writing, bring it to us, and then we can ask him. We can say, listen, we said you could have 7. What are you doing? Then we have some way to do something for you. Otherwise, it becomes he said, she said, and none of us get anything done. So,
Right. Nobody wants to live like that.
so if we're not going to do anything more this evening on this,
I'd like to thank the board for their detailed consideration tonight. Thank you.
Give them a continuous.
can I have a motion to continue?
I make a motion that we continue the meeting. Are you gonna,
To next month.
next month, December 18th, is it?
Yes.
Yeah.
And we'll get an answer from Kenny.
We should put that in the motion.
Yeah. And that we get an answer from Ken, clarification from him where on his memo of 11/12.
And let him, if it's in the good way, should let him know that, so he can kind of,
We'll have him draft the note, send it to us. Do we have a fax or an email or something? Get it to Lisa, and Lisa will send you what we get.
Thank you very much.
Okay? I wish we could have done more for you tonight.
Appreciate it.
but I
Thank you.
think we need to.
We're getting
We need to.
there. Patient endurance.
Yeah, well, that's good. Do I have a second on the motion?
Second.
All in favor?
Aye.
Aye.
Meeting's continued. Thanks for your time. Take care.
Thanks again.
Wishful thinking? Thanks. Thanks.
Want to make a motion to adjourn the meeting?
Yeah, I guess we can.
Second.
All in favor?
Aye.
Okay.
Peter poses.